to the lease?
Give me 1 second. This is for 1144, right?
Yes, ma'am.
Yeah, I had 2 cases for him today, sorry. So for the lease, the rent for this unit is $12.99.
12,067.
1,299 is the rent for this unit. Was that the question?
Yes, and what is the total amount of back rent due as a result of the defendant's failure to pay?
So back rent is September, October, November. Second. $3,897.
And is that the amount that you're asking the court for back rent amount?
That is correct.
And a 3-day notice was served on the defendant?
That is correct.
Mr. Just a moment. That back rent amount is back rent only, no late fees, no utilities. Is that correct?
That's correct, Your Honor.
Okay, my apologies. Go ahead, Mr. Roberts.
And you're asking the court to pay that amount of
$897.
Are you asking the court for cost of court
Yes, court costs and attorney's fees.
and possession of the property, correct?
In possession, that is correct.
Your Honor, we'd ask the court to take judicial notice of the contents of the file. And I would testify that our attorney's fees is reasonable necessary in the amount of $1,500. That includes 4.7 hours in preparation and up to date. In addition to, Your Honor, we've agreed to limit our fees to $1,500.
Thank you, Mr. Roberts. At this time, the court grants judgment for the plaintiff. Award plaintiff possession, back rent amount of $3,897. There's $1,299 in the registry of the court. The court will disperse those funds to the plaintiff to offset the amount of back rent owed. The court is awarding plaintiff $1,500 in attorney's fees, requiring a supersedious bond in the amount of $12,990, with a writ of possession to be issued no sooner than December 2nd. Thank you all. You may be excused. Have a great day. Good afternoon. At this time, the court calls case number 1235851, Oasis at Piney Point versus Shaniqua Taylor. Can the parties please state their appearance, beginning with plaintiff first?
Mark Roberts on behalf of the plaintiff, Your Honor.
Thank you, Mr. Robertson. For the defendant?
Eric Quatler on behalf of the defendant, Your Honor.
Okay, thank you, Mr. Quatler. At this time, I will swear in all who plan to provide testimony. Can I please get you to raise your right hand? Can you unmute Ms. Taylor, please? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes.
Yeah.
Thank you. You may proceed with your case in chief, Mr. Roberts.
Your Honor, we had started.
Sorry, Your Honor, but they rested.
Okay, it's up to you to, I'm looking at my notes now. Thank you.
Your Honor, there's also a procedural matter, Your Honor. We'd filed contemporaneous to the prior hearing a motion for immediate possession since the defendant has failed to pay rent with the exception of the initial rent. We'd request that to be heard.
A motion for default?
A motion for failure to pay, continue to pay in the registry of the court, Your Honor, yes.
Your Honor, I don't see the motion.
Have you provided opposing counsel with a copy of the motion, Mr. Roberts?
It's my understanding it was, Your Honor. Just other.
That is not my understanding.
On which date?
It'd be the same date that was provided to the court, Judge. You know what, Judge? They have not, we do not have a notice of appearance for them, Your Honor.
Did you provide it to the defendant?
I'm looking, It's my understanding it was, Judge.
What date? Do you see it, Ms. Myers, the motion for default?
I'm checking now, Judge. 1 second.
I see a notice of appearance of counsel. That was yours, so Mr. Roberts. Okay.
I don't see a motion for default, Judge. However, I don't know if it may be still pending with e-file, but it's not been accepted by e-file at this time.
Okay.
No, I
Did you hear
stand
that?
correct. I heard that, Your Honor. I guess I stand corrected, then, Judge, if it's not on e-file, but.
It could have been e-filed yesterday and hadn't been processed yet. And if it was just filed yesterday, that's not timely notice to the defendants either.
No, well, my understanding, Your Honor, it had been filed 2 weeks ago.
I don't see it, and Ms. Myers doesn't see it.
Very good, Your Honor.
Okay. All right. You may begin with your case in chief, Mr. Quartland.
Thank you, Your Honor. May I call my client?
Yes, you may.
Okay. Good afternoon, Ms. Taylor. Can you tell me, did you receive a notice to vacate?
Yes,
Okay. What day did you receive that notice to vacate?
August, like mid-August.
Okay. Plaintiff claims that they delivered it on August 13th. Would it surprise you that that was the date?
Yes, that sounds about right.
Okay. Tell me about that day. What were you doing?
I work from home. I'm a case manager, so I was here all day.
Okay. And do you have any security precautions that you take while you're at home?
Yes, I make sure I lock my deadbolt as soon as I get in because I live alone.
Okay. Can that deadbolt be open from the outside?
No,
Okay. Is there any other way into your apartment aside from breaking a window?
the balcony,
Okay. And what floor do you live on?
second.
Okay. So the only traditional method of entry to your apartment is the front door.
Yes,
Okay. All right. Tell me about the notice when you received it.
Objection, leading, Your Honor, open-ended.
I'm going to sustain the objection.
Okay. What did the notice look like when you received it?
it was folded up on the floor.
On the floor. Okay. And was there any evidence that it had been secured to the door?
No,
Do you have the original notice?
yes,
Can you please show the court? Okay, a little farther back, we're a little blurry.
okay.
A little blurry.
Is it
Your Honor,
better?
I would object to the admission of this that has not been timely provided to the plaintiffs.
I'm sorry, Your Honor, this is
That's
their
your-
exhibit.
I'm going to say that. That's your exhibit, right, Mr. Roberts?
No, Your Honor, she's saying that that's the original one supplied her. We
But it-
provided the copy of what was delivered to her, Your Honor. If
But
she's
it's still
claiming
the
that,
same. It's
if
still
she's-
the same document. What's the difference if yours is a copy of this?
she's saying that there is physical evidence that it was not attached. And she has not provided that physical evidence attached to that notice. She's saying this is a notice that has no evidence that it was attached. That's what they're, So
I'm going to overrule the objection, sir.
Okay.
Okay, I'm trying to get it to focus. I don't know if it's my jittery hands, but
Okay. So I tell you what, is there any residue from anything on that notice?
objection vague and objection, and I'll continue to object, Your Honor. We were not provided a document, a copy, or an accurate picture that we could assess prior to today's hearing. My continued objection, as well as, Your Honor, it requires the question is vague and it's not and it's misleading.
Your Honor, if he wants to continue object, that's fine, but it's essentially admitting that his copy of the exhibit is not best evidence.
That's not true. What I'm objecting to is you presenting a copy of a document that you claim has no residue, that you claim has to have residue, which it doesn't. But you're claiming it is proof it wasn't affixed to the door.
Your Honor, I thought we'd already.
I'm going to overrule the objection and you may proceed.
Thank you, Your Honor. Okay. Ms. Taylor, you said you found it on the ground?
Objection
Yes.
leading.
It's just
She
actually reiterated.
testified to that already, Mr. Roberts.
And again, Your Honor, if she testified that earlier, it's been asked and answered.
Okay, let's just move it forward, Mr. Quadler, please.
Okay. All right. So, that notice, is there, you know what? I'm done with that. Okay. Let's see. I will pass the witness.
Any cross-examination, Mr. Roberts?
Just briefly, Your Honor.
You may proceed.
Ma'am, you don't dispute that you got the notice on the date that it was dated. Is that correct?
Yes,
And you don't dispute that you responded to that. Is that correct?
Objection relevance.
Your response, Mr. Roberts?
If she responds to it, it affirms that she received it, Judge.
Doesn't matter whether she received it, Your Honor.
I'm going to overrule the objection.
And
You can answer the question, Ms. Taylor.
may you repeat the question again?
You responded to the notice after receiving it, correct?
Yes,
And when you appeal this case, did you pay into the registry of the court?
yes,
How many times have you paid into the registry of the court?
One
Objection
time.
relevance.
No, it goes to the issue of truth and veracity. You were aware that you were required to pay into the registry of
Wait,
court.
hold up. There's been no ruling on the objection.
Right. And why is this relevant? And you say truth and veracity and what
Yes, Your
respect?
Honor. It goes to impeach your credibility, Judge.
How?
I'll allow it temporarily, but I don't see how that's going to happen. But go ahead.
You can answer the question, ma'am.
repeat the question?
Did
You're aware
pay?
that
Oh, go ahead, Mr. Roberts.
you did not pay in the registry of the court other than one occasion, is that correct?
Yes,
Okay. And you don't dispute the amount of rent that is in controversy, do you?
I'm not sure exactly the amount,
You don't
because
dispute
some
the,
of the fee was added.
you don't dispute that when you received the notice that you had not paid the rent? You know, notice to vacate.
I don't dispute that when I received the notice, I haven't paid. I'm a little confused at the question.
It's just exactly what you just said. The question is, you don't dispute that that the time you received the notice to vacate, you had not paid that month's rent, correct?
Yes,
And you don't dispute, other than paying to the registry court one occasion, that you have not paid rent since that occasion. Is that correct?
yes.
I pass the witness, Your Honor.
Can you redirect, Mr. Quadler?
No, Your Honor.
Okay. Any additional witness, Mr. Quadler?
Yeah, I call myself for attorney's fees, Your Honor.
I'd object, Your Honor. We weren't noticed to that.
Your Honor, the Texas Property Code specifically says I don't have to notice them.
Okay. I'll hear from you on the attorney's fees, Mr. Quadler.
Okay, thank you, Your Honor. My name is Eric Wadler. I've been practicing since 2011, primarily in this area of law. I am the managing attorney of the Eviction Right to Counsel Unit at Lone Star Legal Aid and an adjunct professor of landlord tenant law at South Texas College of Law, Houston. I have spent well over 10 hours on this case. However, I'm limiting my request to 3 hours for trial time as well as 2 hours for trial prep time. I'm happy to go more granular if the court requires, but that is a significant reduction from the actual amount of time I spent on this case.
Thank you, sir. Any cross-examination, Mr. Roberts?
No, Your Honor.
I apologize. One more thing, Your Honor, if you don't mind.
Go ahead, sir.
My rate is $400 an hour. It's reasonable and necessary for this area of law and my level of expertise in this jurisdiction.
Thank you.
And-
Any cross, Mr. Roberts?
Yes, Your Honor. Eric, is this your primary role, or your primary job is you're representing or your work with the legal aid,
Yes.
and you're an adjunct? Is that secondary?
Yes.
And you receive a salary, is that correct?
I'm not sure why that's relevant.
You receive a
Is that
salary,
an objection?
No. Yeah, I received a salary.
and your testimony is it was 2 hours for trial time, or is it 3 hours? 2 hours for
3 hours for trial time, 2 hours for trial prep.
no further questions, Your Honor.
Any redirect of yourself, Mr. Quatler?
No, Your Honor.
All right, thank you. At this time, any additional witnesses?
No, Your Honor.
All right, at this time, the court grants judgment for the plaintiff.
Your Honor, I was hoping I could make a closing statement.
Okay, I thought you had rested. Typically don't, but I'll give you an opportunity to make a closing statement, Mr. Quatler.
Okay, thank you. Your Honor, plaintiff has the burden in this case. My client testified under oath that she was present in the home the day the notice was delivered. She testified that the deadbolt, which can only be unlocked from the inside, was engaged that day, making it impossible for plaintiff's representative to have entered the unit and taped the notice to the door. She testified that instead of doing that, plaintiff's representative shoved the notice to vacate through the crack of the door. To substantiate this, my client showed the court the original copy of the notice to vacate, on which there was no residue indicating it had ever been taped to anything. Mr. Van Vliet, however, had no such personal knowledge. He testified, no doubt truthfully, that someone else claimed to have delivered the notice to vacate properly. Someone who was not before the court, someone who was not under oath at the time. Plaintiff would have this court believe that it is more likely that my client committed a crime by lying under oath than it is that a previous employee cut corners and wasn't entirely truthful about it. They would have this court accept a position that is contrary to the most fundamental thing on which we require Occam's razor, which is more likely that someone who's not here wasn't entirely truthful, not under oath, or that my client lied under oath. There is no reason to believe my client lied under oath, and we're asking for a take-nothing judgment for a defendant.
Okay, at this time, do you want a closing opportunity for a closing, Mr. Roberts?
Just briefly, Judge.
Go ahead.
The defendant never stated that the notice was not taped to the door. She merely stated she found it on the floor, Your Honor. In addition to the fact, she never stated that she stated she was at her apartment that day, but she never stated she ever left the apartment that day. In addition, the procedural policies, as well as the Texas Rules of Evidence, in regards to the documents and verification that were provided and acted on as business records and business policies, were effectuated and testified to. Accordingly, Your Honor, the evidence would support that it was done properly, as well as the fact that the witness never testified that it was not taped. So,
Your Honor, I'm going to object that that is a misstatement of witness's testimony. She specifically said there was no tape ever on the notice.
that's
Okay.
your interpretation.
Okay,
No, that's literally
I'm ready to issue my ruling. At this time, your objection is sustained, Mr. Quatler. At this time, the court grants judgment for the plaintiff awarding plaintiff possession, back rent amount of $4,236. There is $1,051 in the registry of the court. The court will disperse those funds to the plaintiff to offset the amount of back rent owed. The court is awarding plaintiff $1,500 in attorney's fees, requiring a supersedious bond in the amount of $10,510 with a writ of possession to be issued no sooner than December 2nd. Thank you all. You may be excused. Have a good
Thank
day.
you.